The Department of Justice under Attorney General Bondi, along with 25 states and multiple Second Amendment organizations, have now joined forces to support the fight against statewide concealed carry ban laws. This challenge is gaining serious momentum and is heading to Supreme Court conference in just a couple of weeks. Today I'll break down what's happening in this critical case and share updates that affect states like New York, California, Hawaii, and others that are currently attempting to restrict or outright ban concealed carry. At the center of this fight is the Hawaii case of Woolford versus Lopez, which is now seeking emergency Supreme Court intervention. This case revolves around a preliminary injunction and a Ninth Circuit ruling that upheld Hawaii's sweeping public property carry ban, claiming it was consistent with the Second Amendment. Recently, in a move that surprised many, the Trump DOJ, Attorney General Bondi, and the 2A Task Force stepped up in support of the plaintiffs. They filed an amicus brief urging the Supreme Court to finally review these concealed carry ban laws that were passed directly in response to the Supreme Court's landmark Bruin decision. In their filing, they emphasized that the lower courts have been openly defying Bruin, and that it's time for the Supreme Court to step in and put a stop to it. Interestingly, they also hinted that the court should eventually take up challenges to statewide rifle bans and magazine bans, which have been implemented in multiple states. This effort has now been joined by 25 pro-Second Amendment states, all pushing the Supreme Court to grant review and put an end to these unconstitutional restrictions. The momentum behind this case is building fast, and it is set to be considered by the court in the coming weeks. For context, here's what this case is really about. The state of Hawaii recently passed a law designed to undermine Bruin by heavily restricting concealed carry. Under this law, individuals could only carry on private property if the owner gave explicit permission, either verbally or by posting a sign. This default rule essentially flips the burden, making concealed carry nearly impossible across most of the state. Critics argue this new law is even more restrictive than the one that existed before Bruin. Keep in mind, Hawaii already had one of the most hostile systems in the country when it came to concealed carry. Over an 18-year period, the state issued only a handful of permits, and in at least one county, not a single permit was issued. Given this history, when Hawaii passed this new law, the plaintiffs immediately sued to have it struck down. Now, this case has a difficult road ahead when it comes to getting Supreme Court review, mainly because it's still at the preliminary injunction stage. Historically, the court has denied review to most cases at this point in the process. However, what makes this challenge different is that it now has the official backing of the United States. The Trump DOJ's support gives the case a much stronger chance of being heard. In the amicus brief filed by the Trump DOJ, they made it very clear that Hawaii's near-total ban on concealed carry is flatly inconsistent with Bruin and the long history it recognized. Bruin held that ordinary law-abiding citizens have a general right to carry arms in public for self-defense, and Hawaii's law directly conflicts with that principle. One of the more surprising aspects of the DOJ's brief is that they encouraged the Supreme Court to take up this case at the preliminary injunction stage, something the court almost never does. They argued that this case doesn't need to wait for a full trial or final judgment because the issues are already clear. And in fact, Hawaii itself, along with the Ninth Circuit, previously admitted that there was nothing more left to develop in the lower courts. That's an important point. In its current filing, Hawaii is trying to argue that the case is premature and that the Supreme Court should send it back down so more evidence can be developed and the trial court can issue a final ruling. But that completely contradicts what Hawaii told the Ninth Circuit. At oral arguments, Judge Schroeder directly asked Hawaii's counsel, "What else is there left to decide or to litigate in this case?" Counsel for Hawaii responded, "We think there isn't anything. At the end of the day, these are not Second Amendment violations." That statement was taken by the Ninth Circuit as a judicial admission, which is binding and conclusive. Now Hawaii is trying to change its position, essentially trapping itself in its own contradictory arguments. In his most recent filing, Mr. Woolford called out this contradiction, pointing out that Hawaii is now claiming their court is underdeveloped, while previously stating the exact opposite. This undermines Hawaii's credibility and strengthens the plaintiff's case for immediate Supreme Court intervention. Woolford also responded to Hawaii's attempt to lean on state history to defend their law. Hawaii argued that because the state has restricted the carry of weapons in public spaces since at least 1852, its default ban is therefore constitutional. Woolford pushed back strongly, saying that Hawaii is essentially claiming that its own local tradition outweighs the national founding principles of the Second Amendment. He described that argument as not only wrong, but self-evidently frivolous. At this stage, the plaintiffs are making several important points. They emphasize that Hawaii has already conceded in the Ninth Circuit, and for the purposes of this Supreme Court petition, that there is nothing further left to be developed at the lower court level. Because of that concession, Hawaii cannot now turn around and argue that the case should be sent back for more evidence, more review, or a full merits determination. They also stress that Hawaii's attempt to rely exclusively on state-specific history and tradition is fundamentally flawed under Bruin. The test set out in Bruin does not allow one state's local history to override the nation's overall constitutional tradition and the original understanding of the Second Amendment at the time it was adopted. Hawaii's argument that its own past practice justifies a blanket carry ban runs directly against the standard established by the Supreme Court. Another critical point raised is that the Ninth Circuit itself relied on Hawaii's concession in reaching its ruling. That means Hawaii cannot now backtrack and deny its own statements simply to try and avoid Supreme Court review. Doing so exposes the state's legal position as inconsistent and weakens its credibility before the court. With the Trump administration, 25 states, and multiple national Second Amendment organizations now supporting this challenge, Hawaii may have effectively trapped itself. Its arguments to push the case back for further development directly conflict with what it already admitted to the Ninth Circuit, which increases the pressure on the Supreme Court to take a closer look. As of now, this case has been officially set for Supreme Court conference on September 29th. That means in just a short time, the justices will consider whether to grant emergency review of this concealed carry ban challenge. Historically, the court has been reluctant to step in at this stage, but with Hawaii's clear concession on the record and the strong push from the DOJ and pro-Second Amendment states, there is a real chance that the court may decide differently this time. After the September 29th conference, we can expect to see the results on the court's order list the following Monday. That will be the first clear indication of how the Supreme Court plans to handle this case. Until then, all eyes are on the court to see whether it will take up this challenge and, in doing so, reshape the future of concealed carry restrictions nationwide. As always, I'll continue tracking this case closely and keep you updated as soon as new information is available. If you'd like to support the channel and stay informed on these critical developments, one of the best ways is to subscribe. Thank you all again for your continued support.